Can you tell us the event that took place before the trial?
So before the trial, Jeanette Randolph called the police,
stating that Mr. Randolph had taken her son and she did not know where they had went.
And when the police arrived, she told them that her husband has cocaine in his bedroom.
At the time where both the Mr. and Mrs. Randolph were present.
And then the police asked Mr. Randolph if they could search the house.
And Mr. Randolph certainly did not give them consent.
The police entered anyway because Janet had given them the consent they wanted. They obtained evidence and he was then charged with drug possession. Randolph then declared that the search was unlawful and violated his Fourth Amendment rights.
It went on from there. Georgia argued that the search was constitutional because the wife gave consent already. But the appellate court and the Supreme Court of Georgia also supported the respondent. The court is now in session. Ms. Hung.
Madam Chief Justice, and may it please the court.
First,
the issue on the table
it is necessary to
Janet
recognize that
Randolph, the wife of the respondent,
when a party consents by their physical
is her and her son's lives.
So the main topic of concern is to determine whether or not Janet has common authority to consent.
Can you tell me your name and what do you represent in the court?
My name is Daniel Lee and I represent Mr. Randolph in Georgia v. Randolph. I'm a respondent representing Mr. Randolph in this case.
Can you introduce your fellow teammates?
Oh, so I have two teammates. One is Sunny Wong. She's a Harvard Law grad. She works for the ACLU, American Civil Liberties Union, and they really care about the constitutional rights. And the reason why she was on our side is because she thought that the police and Janet Randolph took away Mr. Randolph's Fourth Amendment rights, and therefore she decided to argue for Randolph. The other teammate is Henry Ho. He's a fifth-year associate, and he stated that Janet Randolph didn't have common authority over the house because the house was under Mr. Randolph's name and because the rights could not be infringed upon.
Can you tell us some of your main points of your argument?
First of all was that, first of all, the police had to get a warrant before the search, and that does not take any effort. The police had to take the basic investigatory step in conducting the search. And second, how she did not have common authority over the house.
First, it is necessary to recognize that common authority can only be established when there is a reason to believe both parties, Scott and Janet, have control over the same property. However, it is known that Janet's reason for returning to Georgia was never registered under record or oath, so her authority over the property cannot be justified. And Officer Murray had insufficient knowledge on both parties' familial circumstance, so he cannot predict or presume that she had common authority. Additionally, Scott was present at the time Murray asked for consent, meaning that the words of a co-occupant without common authority had outweighed the occupant's objection, thus violating the Fourth Amendment.
I'm Vivian Liu. I'm from the United Nations Office on Drugs and Crime. I am the amicus curiae for the petitioner. My teammate, Mr. Xie, graduated from Harvard Law School. I graduated from Yale Law School, and my teammate, Ms. Hung, graduated from University of Alaska Fairbanks.
Can you give us 3 main points from your arguments?
So there's the emergency exception, the consent exception to the warrant, and also the First Amendment right to life, liberty, and justice.
According to the Universal Declaration of Human Rights by the UN, everyone has the right to safety, liberty, and security of the person. America holds a powerful place in the UN and in the world, and with great power comes great responsibility. If today, the court rules that her husband's objection overrides her consent, the court is not only taking away the wife's right to safety, liberty, and justice, but is also setting an example to other nations that they can ignore international laws. The Supreme Court holds immense power and influence, and has the duty to preserve people's right to life, liberty, and safety. I ask the court to keep in mind how its decision will affect people's rights and international order when making their decision. Thank you.
I'm Justice Miyazono. I was appointed by President Richard Nixon, former President Richard Nixon. And for this case, I was one of the justices. 1 out of 5 of the justices. We have Chief Justice Kuo. She's been on for around 40 years. And we have Justice Muir from Canada. He was appointed by President Obama, and he's been on for around 8 years. We have Justice Ma, who was appointed by President Trump. She's been on for around 3 years. And we also have Justice Wu. She was appointed by President Kennedy. She's been on for the longest time.
Okay, so how are you feeling before the case? Before they presented the evidence to you?
Well, before the case, we were not very sure where we stand on the issue.
I was very nervous because I had mixed feelings about this whole situation. And I knew that this decision would affect so many other couples' lives.
I was looking forward to it because it's our decision would be a big one.
Before the trial, I was excited. This was an issue that I hadn't thought much about. And so I was excited to really get into the debate and pick the brains of my fellow justices.
Well, before the trial, I was nervous because I had to talk to 5 intimidating justices. But because the pieces of evidence were in our favor, I was confident.
Our team is morally correct, and so I was feeling very confident about the case.
Madam Justice, Madam Chief Justice, and may it please the court, this is Daniel Lee. Long story short, our side believes that the Sergeant Murray should have gotten a warrant in the first place.
Can you tell us, when you were listening to the other side, their evidence that they have given?
So I think they mainly gave points based on 2 cases. One, probable cause, and exigent circumstances, both of which our side has to explain through and get the definition over with.
I'd like to read off the legal documents of what qualifies as an emergency exception. There are actually multiple, but only 2 currently relate to our case. 1, if the police officers have reasonable belief that someone's life is in danger. And 2, if the police officers have reasonable belief that any evidence might be disposed of. So I think we need to take emergency out of the traditional context that you are using right now. Emergency does not only refer to a person's life's danger. Emergency also refers to evidence. The emergency of losing said evidence.
There are exactly, under the legal definition, 4 cases in which the police can search without a warrant. Let's start from 4 and go to 4, exigent circumstances, again emergency. And the opposing side called it an emergency where Jeanette Randolph just knew about the cocaine and how he was abusing it. Although they just visited Georgia for 2 days, they were able to claim that they were abusing it. First, that doesn't make sense at all. And second, what the emergency should actually have been is the fact that Jeanette Randolph took the kid away for 5 years in Canada. That should have been an emergency instead of her knowing about the cocaine for 2 days. 5 years and 2 days.
Wait, Mr. Lee. I just want you to clarify, how many days did the wife stay in the house before she reported to the police?
It was exactly 2 days. And the kid was safe with the police.
Madam Chief Justice, and may it please the court. The question regarding the case is whether one occupant can give law enforcement officers legal consent to search a shared area of a given home, even when the other occupant is present and rejects to the search. The state of Georgia stands firm in their belief that since the right to life and protection comes first, the occupant may give consent to a search under reasonable cause. We further hold that given the role of the police officer, which is to uphold the safety of citizens and to respond to calls of services, it is without doubt that the police officers acted within their given jurisdictions, and that the evidence taken from the search should be admitted as fully effective evidence.
Is there any weaknesses you see in your opposing team?
Oh, so many. They're morally incorrect. Who puts privacy before safety? Of course you put safety before privacy. First, they went overtime. That is extremely unacceptable. And then second, how dare they pass out papers?
I would also like to invite the justices to think about what their actions may breed in the future, right? Your decision will determine whether or not a suspect, even when there is given evidence that they are carrying out illegal activities, can deny any sorts of attempts to search their property and thereby risk the safety of the public. Your decision will determine whether or not a man or woman engaged in domestic violence can simply hold out a hand and deny any sort of protection from reaching themselves. Your decision will determine the effectiveness of the First Amendment right, of the Declaration of Independence, of the right to life and the right to protection. Your decision will determine how effective our police force is and how safe our citizens are. Your decision can save lives or it can cost lives. And your decision would determine all of this. Thank you.
Thank you.
Thank you for your time, guys.
When you were trying to decide the verdict, was there a specific point that pushed you to one side?
Yes. So I think most of us felt that it was very difficult to decide between who has the correct answer for it, because both sides should have equal rights and their consent and objection should have balanced each other out. But we felt that the police having enough evidence to obtain a warrant before having even to ask for consent from Mrs. Randolph, we felt that the police should have taken that procedure and would have not created this issue at all.
If I only had to solely vote for or solely rule for this case and this case only, I would vote for Randolph because I see that Mrs. Randolph was in no immediate danger. But in other situations, then for other people, then they might have been in immediate dangers, and this would also affect how people can treat the police. To an extent, I agree, but also disagree with what has happened.
He lost evidence, but then he's saying that there wasn't enough to call it evidence because all the wife said was evidence of drug evidence.
Yeah, that was one of his points.
Yeah. But that is enough, I think.
Yeah, that
Telling
is
the police
enough
that-
for point.
Can you tell me some strengths and weaknesses of the petitioners?
For the petitioners, their arguments were really well organized, and they were primarily basing their argument on the situation being an emergency, so the police having the right to search without a warrant. I think the strongest point in their argument was the wife having having the right to consent as well as the husband does. So they have equal rights, they have common authority over the premises at this point.
What are some weaknesses?
Some weaknesses were that the speaker could have clarified the situation more, as we were very limited in information.
I think that's a bigger problem here.
Also, you guys do not all have to agree.
Yeah.
So,
This one was like a lot more specific. It had like kidnapping.
sorry,
cases, but then
sorry, it's their class.
Okay, here, let me read this
I
paragraph.
think the whole child part is relevant because they
Yeah.
tell the same
Unless
So for the respondent, what were some strengths and weaknesses of their argument?
Well, first of all, the respondent started off really prepared, giving out papers. The strength of their argument comes from the fact that they argued Mr. Randolph's Fourth Amendment rights has been violated in the search, and that the consent of one person does not override the objection of another person.
There are many faults, including random facts that are totally unrelated to this case. There are miscellaneous facts, and there are surprise attacks that I think Georgia did not expect. And these were facts that have swayed the other justices, but have not blinded me.
I think we got what we wanted.
Nervous people waiting. Nervous people waiting.
How did you feel after the trial, but before the justices gave their opinions?
So we were really nervous about the verdicts because we were both confident that our side won. So we basically gathered up with the petitioners and continued debating. Just like how we regret after the interview, oh, I should have said this, I should have said that. We were just reminded of ourselves of the points that we didn't mention during the debate that would have helped the justices make their decision.
We will now read off the votes. Justice Mueller.
in the end, I voted for with the majority and voted in favor of Randolph.
How did you feel about the verdict?
Overall, the verdict was a very difficult one, and was, I think the vote itself does not display how much it was disputed among the Supreme Court justices. It was one that was very difficult because a lot of the situation was circumstantial, and bearing in mind precedents and what had happened before, it was in fact a difficult decision. However, we do believe we came out on the right side in the end.
So the conclusion we came to was 4-1. We decided that Mr. Randolph's side was correct, and I voted along with the majority. So I think the verdict was correct.
Who did you vote for?
I supported the respondent. Considering that I chose the side of the verdict, I think it was the best option with the situation provided for us.
How did you feel about the verdict?
I mean, 4-1 for Randolph, so I guess that's a satisfying result.
Our team kind of expected it because even though we're morally correct, the law does not support our team, which I'm very disappointed in. And I'm also disappointed in the justices for choosing the opposing side.
I voted for Georgia because I believe this case will affect the lives of so many other people, and that this decision also would change the definition of the Fourth Amendment right. And if there is sufficient evidence that you are breaking the law, then there is a limit in which your Fourth Amendment right should be used.
Randolph.
Georgia.
Randolph. With a decision of 4-1, the court rules that police do not have the right to search private area without a warrant and should have obtained a warrant before searching Mr. Randolph's house. Thank you.